I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. I bet the sun gon' shine on me. All of the pain inside, it's hard to let the shit ride. Homicide, why they take my nigga life? Seems I got some shit with my family, I'm trying to get it right. 2 daughters, 2 mother, 2 family, that's right. This the shit I live for, I keep that shit they kill for. Try to kill my spirit, yeah, my music what I heal from. Keep that weed coming, cause I ain't trying to feel nothing. That shit broke my heart when I caught my cousin stealing some. Tell me why me when I'm really trying to build some. Fed some young niggas, little bitches set me up, huh? Should've killed them niggas since then, I done triple boy. Probably 25 to life, I pull it from my hip, yeah. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm, yeah. I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. April 11, I lost my pops. 10 months later, my daughter dropped, and you can't tell me life can't transform, and you can't tell me that I ain't the one. I done took blows from friends and family. I done made money with friends and family. When you get broke, just watch it and handle it. It's time to ride, and niggas ain't down for you. Find that fire, and then you start racking. You find that plug, and then you start stacking. And niggas is robbing, you better stay packing. Ain't doing no talking, just know it's by action. Saying you love me, give me expression. We don't take pleas, ain't doing no confession. Nationality, I swear it's a blessing. Knowing I'm a king, and I got the recipe. Give me the keys, you know I'm gonna run it too far in the game. Ain't doing no front, let's get to this money. You coming, lil' mama, LRP, and we way up in gun. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine on me.
Alrighty, peace, love, and law, everyone. Welcome to In God We Trust Academy podcast, work session season 7. Today, I'm gonna give you guys a few more minutes to get in here, get locked in. Make sure you guys like, share, and subscribe. How y'all feeling in here today?
Feeling great.
Everything good. How about you?
All is well, man. All is well. No complaints. Alrighty, while everybody's coming in, we're gonna give a few announcements to you guys. Don't forget, every Monday and Wednesday we're here doing the In God We Trust Academy podcast work session. We're in season 7 at this moment right now. It is every Monday, 11 a.m. Central Time, Wednesday, 6 p.m. Central Time. If you want to be able to join and be able to talk with us as well, then make sure that you send an email to admin@ingodwetrustacademy.org. Again, that's admin@ingodwetrustacademy.org, and just say you want to join work sessions. Okay, right now, October the 25th, 2025 at 3 p.m. Central Time, we're going to be doing a class, and this class is called Paid in Full. Is where I'm going to teach you a method of where I took a $25 money order and literally paid a bill off and received the full car title free and clear, and it's backed by federal court records and a dismissal with prejudice as well. As me and the particular bank came to a agreement, and it won in my favor. So if you're interested in learning this method and learning how things go, especially the VIP section, it's also going to include a workshop that goes along with this, with the ebooks and things like that. But we just want to make sure that you guys get started and on the correct path as well. So there are 2 tiers. There's a VIP tier and a actual regular tier. So you can just go to ingodwetrustacademy.com and be able to get involved in that. Remember, that's October the 25th. And also, we got our class next Saturday, September the 13th, the Bill of Rights class, where we're going to go through each and every last one of the Bill of Rights for you guys to make sure that you know your rights and how to exercise those things and be fully aware with them, even when you're amongst these so-called public defenders and things like that. So how to literally protect everything about you is what you want to know how to do. And we're going to go through that. Yes, it will come with a ebook, templates, and stuff like that as well. There has been a lot of info been placed into this as well. So we're going to have a good time, man. Make sure that you do this with your families as much as possible. It is $50. So, get as many people as you can involved in your household so you guys can truly learn your rights. This is very important, especially if you have teenagers, things of those nature, right? You don't want things to start happening and then you don't know your rights, especially when you got children, because it happens a lot, right? It's a couple of things I've seen going around back in my hometown at a school called Dessler in Tuscumbia, Alabama, and it involves minors, and these minors have no idea about their rights, and, they're just trying to do things that impede upon those minors' rights, but the parents are not even aware. Some of them are, some of them not. But again, it's just one of those things. So remember, it is $50 donation for that. Go to ingodwetrustacademy.com. Okay. All right. So how y'all doing here? Y'all good?
Yes, sir.
Yes, sir.
Yeah. All right. I asked some of y'all earlier. Been a few more of y'all came in here today, and y'all
All
do
is
sound
well.
good. That's what's up. That is what's up. What's going on, Jessica, Haley Smith, Corey Johnson? How y'all doing out there as well? Anybody else that's watching us from TikTok, YouTube, Twitch, as well as Facebook as well. So welcome, guys. Welcome. All right, so we're going to hit this record button. I'm ready to get started today. We got a lot to cover. So let's jump right into it. Get you guys going. I know we got somebody with a testimony, though, so go on and get them hands up. All right, go on and get them hands up. All right, welcome to Work Session Season 7, my beautiful family. And we are here to continue to move forward. We give thanks for each and every last one of your participation and everything that you guys do here with us, giving us your testimonies and also showing us that the work that we put in here is not in vain. So again, we just give thanks. Also, everything that you hear from this point on is for educational or religious purposes only. Anybody seeking any form of legal advice, please do seek a legal advisor. okay, as it is my religious duty to speak my religious truth and experiences here with you guys today. So with that being said, we got somebody that got their hand up. If you got a testimony, go ahead, Miss Richie.
Greetings, peace, and love to everyone. It's a small testimony, but it's a testimony. I received my letter back from Alabama State Bar that I wrote on the attorney from State Farm on behalf of my daughter's case. And they said they didn't see anything wrong with what he did because he represented State Farm instead of my daughter. So with that being said, I'm working on my Rule 17, and I sent my reconsideration letter out to them today. Small wins.
All righty. Well, keep on moving. Keep coasting. Keep pushing. Absolutely. Is there anybody else? Anybody else with a testimony today? Oh, well, let me ask you this. Are y'all working? Y'all got some iron in the fire out there?
Yes, sir.
Okay. That's one person. Rest of y'all working?
Sure
Yes,
am.
we do.
Yep, sure am.
Okay. Stay at it. Stay working. Time plus consistency equals growth, guys. So do not stop. Do not stop. Guarantee me that you guys are not going to stop. Gotta keep going, man. Perseverance is everything, guys. Alrighty. Let's get started. Since we have no more testimonies at this time, we're gonna jump on into this.
I got a small one.
Go ahead.
My credit score went up 35 more points, y'all.
Congratulations.
That's not small. That made more money. That's what that mean. More money, less problems. Straight up. So congratulations on that. Keep it going. All right, guys. Today, what we're going to be speaking on, I don't want it to do this though, so hold on. Today, what we're going to be speaking on is trial warfare, lawful strategies for jury and bench trials. And we just want to make sure that everyone knows what's going on. Okay? Want to make sure you know what's going on when you get in the trial. And a lot of people get scared, you get nervous when you go in there, but that because a lot of the times that happen because you go in there without a game plan. And if you do have a game plan, no matter what, deal with it with what you have already wrote. Stick to what you know. But the main thing people need to learn when it comes to these type of thing is your job and duty is to preserve the record the best you can. If there's no court reporter, that means we have to make sure that we write all of our objections, etc., and make sure that we place them on file on the docket. Everything. So it's your duty to preserve the record, especially when things are said orally. Okay? So, trial, warfare, lawful strategies for jury and bench trials. Okay, so why a trial? Understanding the risk and strategy of litigation. A trial is the final stage of a legal dispute where facts are formally determined in open court. While many people assume that every case must go to trial, the truth is that trials are often risky, expensive, time-consuming, and avoidable. The courtroom is not designed for a casual debate. It is a formal forum where the stakes are high and the outcome is final. The necessity of trial typically arises only when earlier opportunities to resolve the matter have been lost or mishandled. Many disputes can and should be resolved before a trial if the parties properly assert their rights at earlier stages. So again, if you can come with the most powerful, whether it's affirmative defense answer, whether it's a petition, etc., if you can come with the most powerful answer or petition, which is truth, proof, Okay? Truth, proof, law, and relief. If you can remember those 4 things and you got it to where it's prima facie evidence of what you're saying, then there's no need for trial. You will definitely win unless they're stupid enough to take you to trial, in which they will try to settle out with you out of court, which is what happened with me with this bank when I used my $25 money order, right? So a case usually proceeds to trial because of avoidable mistakes, weak or insufficient pleadings. If the complaint, petition, or answers fails to allege the facts that establish a claim or defense, the court cannot rule in your favor without a trial. Okay? So that means they would have to take it to trial in order for them to rule in your favor. Incomplete discovery. When evidence is not demanded through the 5 discovery tools, interrogatories, depositions, requests for production, requests for admissions, and subpoenas, key facts may remain unproven. Also, failure to object, not placing timely objections on the record to judicial errors or opposing counsel tactics can waive critical rights. No court reporter. So without a record, you cannot challenge the improper rulings or preserve issues for an appeal. So that is why I say you need to make sure that you say your objections, make sure that you mark the time of your objection, what you objected about, and be able to file that as a full affidavit into the court. That way it is on the docket, okay? You want to be able to do that. Failure to file for summary judgment. When there are no material facts in dispute, a motion for summary judgment can win the case before the trial. Skipping this step often forces an unnecessary trial. So just remember, sometimes it's just best to go ahead and file a summary judgment right after an answer or anything like that, or just as soon as you file with a petition or even an affirmative defense. Totally up to you. Lack of just cause. Some cases should not proceed to trial because the underlying claim or defense lacks merits. So nearly all winnable cases can be resolved in pretrial stages when pleadings, discovery, and motions are used effectively. Okay, so how the court sees trial. The law is clear. Trial is the arena for resolving disputed facts. Courts exist to adjudicate matters where evidence is contested. Rules of civil and criminal procedure define when cases go to trial and how evidence must be introduced. Each jurisdiction has its own set of rules. Federal rules of civil procedure, state rules of civil and criminal procedure. Always consult the current official rules for your jurisdiction, which is why I say always make sure that you know the procedures. A lot of people quote laws and stuff like that, and that's great. But when you start stepping into these court, you got to know procedures. And procedures will clearly take you to the finish line, to the remedies that you are seeking, right? Summary judgment, if you see Federal Rule, Civil Procedure 56, or state equivalents, allows a judge to resolve a case before trial if there are no genuine disputes of material fact. If you miss the opportunity, trial becomes your last chance. Right to a trial by jury is guaranteed in criminal prosecution by the 6th Amendment to the U.S. Constitution and in certain civil matters by the 7th Amendment and corresponding state constitutional provisions. Appeals are limited. So an appeal is not a do-over, okay? Appellate courts review the record for legal error. They do not retry facts. So that literally means that you need to make sure that you have everything on the record that needs to be there to preserve the record. Without objections and a proper record, your appeal may fail regardless of the merits. So at trial, you will face opposition tactics, objections to your evidence, witnesses with fading or selective memory, and judges or jurors whose attention may waver. Okay? The law requires that you prove the facts you pleaded, but the courtroom environment often makes this task more difficult. Okay? So the best thing to do is preserve the record, just in case you got those type of people in the court. All right? So if your case is already set for trial, this is your final opportunity to secure relief. No new discovery can be compelled. No new interrogatories or admission can be served. Depositions and subpoenas must already be completed. Therefore, your focus at trial must be prove the facts you allege in your pleadings. Stay on track. Do not be led into irrelevant issues or distractions. Be aggressive but respectful. Object to improper conduct, but do so according to procedural rules. You want to make sure that you preserve the record, ensure a court reporter is present, and that all objections and rulings are entered for potential appellate review. Your mission at trial is singular: to establish the facts that support your claim or defense according to the rules of evidence and procedure. So if you have already used your pretrial tools properly, trial should not be necessary. But if you are down to the wire, the trial becomes your last and only chance to obtain a lawful judgment in your favor. Okay? So what are the types? We got a jury and we got a bench. A trial is a formal judicial proceeding where facts are tested against the law in open court. It can be conducted with a jury or without a jury trial, known as a bench trial. The choice of trial type determines who evaluates the evidence and who renders the final verdict. At its core, a trial is not about debating opinions or creating new law. A trial is about applying existing law to establish facts. The party who bears the burden of proof must present admissible evidence that supports their claims or defenses. If the necessary facts were not secured through pleadings, discovery, and pretrial motions, the trial becomes the last opportunity to prove them. So the truth is, guys, we really want to win in our discovery. We should capitalize anywhere between there, and that's already going to determine whether you're going to win or lose based upon how good you use your discovery tools, right? So the two main types of trials, jury trial and who decides what. The jury weighs the admissible evidence and determines what facts they believe to be true. The judge explains the law through jury instructions and applies that law to the facts found by the jury. Process and practice. Before deliberation, the judge reads jury instructions. These instructions guide the jury on how to apply the law to the evidence. On TV, it looks like the jury announces the verdict as if they decided the law. In reality, they are reporting their factual findings in the form required by the judge's instructions. Burden of proof in civil cases. The standard is the preponderance of the evidence, often explained as the greater weight of the evidence. The jury is instructed to determine which side presented stronger admissible evidence. Okay? So, example, if you find the greater weight of admissible evidence shows the defendant entered into a binding contract with the plaintiff, breached that contract by failing to perform, and that the plaintiff suffered damages as a result, you must find in favor of the plaintiff, right? So that is how the actual judge would instruct. The standard is beyond a reasonable doubt. So burden of proof in criminal cases, remember, beyond a reasonable doubt. That is the reason why I say a prosecutor should not lose a case, because he should know beyond a reasonable doubt that he can win a case, right? Right? So the standard is beyond a reasonable doubt, a higher standard than in civil cases. The jury must determine whether the admissible evidence excludes every reasonable doubt as to the accused's guilt. Every jury instructions, jury instructions, if you find based solely on admissible evidence that there is any reasonable doubt whether the accused committed the alleged act, you must find the accused not guilty. If no reasonable doubt exists and the evidence proves guilty beyond a reasonable doubt, you must find the accused guilty. So in both civil and criminal jury trials, the jury does not decide the law. They decide the facts, but only as guided by the judge's legal instructions. The judge enters the final verdicts according to the law. Okay? So now you got a bench trial, which most of these happen in municipal courts or the smallest court in the county. Okay? So a bench trial is a trial without a jury. The judge alone weighs the admissible evidence, applies the law, and renders the verdict. Bench trials may occur in both civil and criminal cases, although many criminal cases carry a constitutional right to a jury that cannot be waived unless the accused knowingly and voluntarily agrees. Equitable remedies such as injunctions, rescissions, or specific performance are almost always decided in bench trials since they involve judicial discretion rather than a jury's fact and finding. Okay? Now, what is the governing rules of the trial? You got the U.S. Constitution. The Sixth Amendment guarantees a public and speedy trial by an impartial jury in criminal prosecutions. The Seventh Amendment preserves the right to trial by jury in civil cases extending $20 in controversies in federal courts, with state constitutions often providing similar or broader rights. Then you got the rules of procedure. You got Federal Rules of Civil Procedures, Rule 3839, provide the right to demand a jury trial in civil cases and govern when a court may instead hold a bench trial. Federal Rules of Criminal Procedure 23 addresses when a criminal trial may be conducted with the jury upon the defendant's written waiver with the court and government consent. Then you got Rule of Evidence, control what testimony, documents, and exhibits are admissible at trial. Okay, so with that being said, legal reality, the judge retains authority over the law, instructs the jury on how to apply it, and formally enters the judgment. The jury is restricted to determining the facts within the boundaries of those instructions, right? And just remember, everything that I'm saying now, that it's your duty to assert. So if you want a jury trial, you have to assert that you want the jury trial, that you want a jury trial. You have to say that, okay? How to use this knowledge. Make the jury your ally. If in a jury trial, focus on presenting clear, admissible facts, eliminate distractions, and don't rely on emotions or arguments alone. Jurors are instructed to weigh evidence, okay? They are instructed to weigh the evidence. We want to protect the record. Always have a court reporter present to record proceedings. Without a record, you cannot challenge errors on appeal. So that is why I say if it's not one present, then you want to be the one that is creating the record, even if it's you only having the record. So if you know you're in a place, there's no court reporter, usually in municipal courts, it's not going to be one. So you just need to make sure you objected. What time did you object? What was the objection about? Make sure that you write that down and be able to write this down as an affidavit and file it on the case just in case you have to make the appeal. Okay? Always know the jury instructions. Obtain the standard jury instructions for your jurisdiction. Florida jury instructions or California criminal jury instructions. Study them carefully, and this is the framework the jury will use to deliberate. So make sure you do that. Decide if a bench trial helps or hurts. In certain civil cases, a bench trial may be faster, less costly, and more focused on legal issues. In criminal cases, weigh the risk. A judge may be less sympathetic than a jury, but in highly technical matters, a bench trial can sometimes be more favorable, right? You can do, in civil, it's not going to hurt you to do bench or whatever, but I just want you to make sure that you know what you're doing. If you know that there's a possibility that you can lose based upon evidence and stuff like that, then you want to make sure that you take it fully to trial type thing. But if you got enough evidence to do what it is that you want to do, then push for the bench to get it to go by quicker. And if it's strong enough evidence, the judge will decide on it so quick just to get it out of their way. So, again, weigh the opportunity for that as well. Stay mission focused. Whether jury or bench trial is your last opportunity, you cannot introduce new discovery tools at this stage. The one objective is clear. Prove the facts you already alleged in your pleadings using admissible evidence. Evidence is the key, and the only way to get the greatest evidence is through discovery. So if you do not understand your discovery tools, then you need to be making sure you study those and go back and get our mastering lawsuit class and defend and conquer. Very great to have those. Okay, so now we're going to set trial and how and when a case is scheduled. So a trial is not automatically assigned a date when a case is filed. In most jurisdictions, the case must reach a point called an issue or pleadings closed. This happens once all initial pleadings, complaint answer, counterclaim, replies, etc. are filed, and any motions directed to those pleadings, such as motion to dismiss or motions to strike, have been heard and resolved. Only after this stage can the case be officially set on the court's calendar for trial. So what they just told you guys is if you made a motion and that motion has been put into place, they cannot ignore it. They have to either grant or deny the motion. If they ignore the motion and try to continue with trial, that is a violation of due process law. And you should object to it and say that you must have a hearing on this particular motion before you continue on to trial, because it is part of your discovery. Okay? Part of your discovery. All right? Keep that in mind. So understanding when and how a trial is set is crucial, because once the trial date is fixed, courts are reluctant to grant continuances or delays without a showing of good cause. Trials may be set in two main ways: by a party on motion. Either party may move to set the case for a trial after the pleadings are closed. If the opposing party raises no objection, the court will generally schedule a docket call, a conference where the court and the parties agree on the trial date and length. By the court, okay? So courts also monitor their dockets and may, on their own initiative, place a case on the trial calendar. The court may issue a notice of trial or call the parties to a docket call to fix the date and anticipated duration of the trial. So once the court sets the trial date, it becomes very difficult to change. Continuance are not freely granted and usually require a strong showing, such as illness, unavailability of a critical witness, or other extraordinary circumstances as well. Okay? So, procedural rules on the setting the trial. You got Federal Rules of Civil Procedure, Rule 16, pretrial conferences, scheduling, case manager, court issue scheduling orders that set deadlines for completions of pleadings, discovery, and trial. You can find pretty much the same when it comes to state, but Rule 40 is scheduling cases for trial. Cases are placed on the trial calendar by the court after the pleadings are closed and discovery is substantially complete. State rules of procedure. Many state mirrors the federal approach. For example, Florida Rule of Civil Procedure 1.440. A case is at issue when all motions directed to pleadings are disposed of. So as you see, they have to be disposed of. If not, they cannot continue, and you should object for the moving on of the trial, because there are certain motions that has not had a hearing, and it will definitely violate due process. All right. And if they try to continue on from that, then that means you guys should know how to do a petition to the higher court, either doing a mandamus or prohibition. Right? That's one of our tools that we get to use, right? We just went over this not too long ago. California Rules of Court, Rule 3.729. Courts must set cases for trial after case manager conferences once the matter is ready. Judicial discretion on continuances. Courts have authority to grant or deny requests to move a trial date. Continuances typically require written motion showing good cause, okay, and of newly discovered evidence, illness, or avoidable conflicts. Absent extraordinary circumstances, courts expect parties to be prepared once a date is set. So make sure that we be trial ready early. Do not wait till the trial date. We want to use pre-trial motions before trial is set. File motions to dismiss, motions to strike, and especially motions for summary judgments if there are no genuine dispute of material fact. Winning at this stage can prevent you money and a trial altogether. Okay? Know that. You got those in your favor. Motion to dismiss, motion to strike, motion for summary judgment, other things, suppression, evidence, all kind of other different motions that are at your hand. Motion to reconsider if you need to reconsider something. Okay? All right. Prepare for the docket call. Be ready to discuss how many days you reasonably need for trial. If you underestimate, you may not be allowed extra time once trial begins. If you overestimate, you might frustrate the court. You need to guard against surprise. So confirm discovery is complete before the court sets the trial. If discovery is incomplete, file a motion to extend discovery or oppose setting the trial date until you have secured necessary evidence. So again, that goes to say, if they don't want to give you the note, then that means we have an incomplete discovery and we need the extension to receive this particular evidence because that necessary evidence or has not been shown or given, right? As far as the original note and things of that nature. Start thinking about that. Changing the date. If you must request a continuance, do so by formal motion, citing the governing rule in your jurisdiction, and provide sworn factual support showing why the delay is necessary. Courts are cautious, so your request must demonstrate necessity, not mere convenience. A trial date signals the final phase of litigation. If you are not already prepared with strong pleadings, complete discovery, and pretrial motions on file, your options shrink dramatically. The best strategy is to anticipate the setting of the trial and secure your position long before the judge calls your case to the calendar. And the way to do that is you're going to be fully prepared. That means you need to be fully prepared from the beginning by having, if you are the petitioner, you have a great complaint with great evidence, with shift the burden to the actual defendant. Now, if you are the defendant, you have a great affirmative answer as well as your discovery tools to use at your hand to see all evidence and things that's going to be used and to make sure that they have the delegation of authority to bring this cause of action, right? We have to be able to do that if you want to win. I know I want to win. Step-by-step process. So trials follow a structured sequence designed to ensure fairness, protect due process, and allow both sides a full opportunity to present and challenge evidence. While the exact order can vary depending on the jurisdiction and the type of case, civil or criminal, most courts follow a consistent step-by-step process. So they have a jury selection. There's opening statements from the plaintiff. The prosecution usually goes first. The defendant accused goes second. The presentation of evidence, the plaintiff presents, or the prosecutor presents evidence and witnesses first. The defendant accused presents evidence and witnesses second. If there's renewal of objections, then you got motions for a directed verdict or judgment as a matter of law. Then you will have your closing arguments. Okay, plaintiff, prosecution presents closing argument. Defendant, accused presents closing argument. Then you'll have the prosecution or plaintiff may have a short rebuttal if the defendant closing included improper or misleading statements. Then the jury instructions will be given from the judge. And then you'll have jury deliberations and verdict and polling jury upon request to confirm unanimity as well. And the sequence is not arbitrary. It is carefully designed to protect the right to a fair trial. And as you can see, it's ensuring that both parties are heard and that they both have the power to, when the burden of proof is shifted, to what to do on those things as well. Okay. So for procedural basis, you know, most state rules of procedure and federal rules, as well as criminal, provide for questioning and selecting impartial juries. Challenges for cause and peremptory challenges are exercised here. You got opening statements. Each party is allowed to present an outline of the evidence they intend to produce. Courts consistently remind juries that opening statements are not evidence, only a preview of what each side expects to show. So presentation of evidence, the burden of proof in civil cases, the plaintiff must prove the claim by a preponderance of evidence. In criminal cases, the prosecution must prove guilt beyond a reasonable doubt. Think about that. Beyond a reasonable doubt. So if they call these actual traffic cases criminal cases, that means they have to prove it beyond a reasonable doubt. So they could say you were speeding. Okay, well, in order for you to know if I was speeding, then we need to make sure the calibration of the speed gun is right. So did you calibrate on that day? You see what I'm saying? Without a reasonable doubt, remember? So if he didn't, then how can we should be sure that it was accurate? So that creates doubt. If that creates doubt, case got to be dismissed. Simple as that, guys. Simple, right? Preponderance evidence is meaning that it's evidence that has been shown, a claim that has been made against you, and it's enough to stick, and it's the job of the defendant to have to rebut those. If you can't rebut it, then the facts are going to stand against you. So rules of evidence govern what can be introduced. Cross-examination rights are guaranteed by the Sixth Amendment in criminal cases and by procedural fairness in civil cases. Objection and motions for directed verdict. Timely objections preserve issues for appeal. A motion for judgment as a matter of law or a motion for judgment of acquittal allows a party to argue that the opponent has not presented sufficient evidence to sustain a verdict. Then you will have your closing arguments where party summarizes the evidence and argue how the law applies. The prosecution, plaintiff goes first, then the defense, and with a possible rebuttal by the prosecution, closing arguments are also not evidence. Then you have the jury instructions where the judge instructs the jurors on the law that applies to the case. These instructions are binding. Jurors must apply the law as given, even if they personally disagree. Verdict and jury polling. The jury announces its verdict in open court. Upon request, the jury may be polled individually to confirm that each juror agrees. All right, as well. So, and the governing authority is the U.S. Constitution, the Sixth Amendment, and the Seventh Amendment. You got the rules of the court, which are the federal rules of procedure, criminal rules of procedure, and the federal rule of evidence, as well as it applies into the states as well. Courts repeatedly affirm that juries determine facts, not law. Judges control jury instructions and enter judgment based on the law, and failing to object timely or to preserve the record often results in waiver on appeal. Okay? So understand the sequence. Map out each stage of the trial in advance. Prepare witness exhibits, arguments in the exact order they will be presented, and use voir dire wisely, which means question potential jurors to identify bias. All right, so we need to make sure and exercise the challenge to secure a fair, impartial jury. So you got to make sure every juror is clean, not close to the family, all of that good type of stuff. It's not anybody that's biased in any type of way. So that also has to be known. You want to master your opening, present a clear, lawful narrative of what the evidence will show. Keep it factual, save argument for closing. You want to build the record, introduce all admissible evidence needed to prove your pleadings, place timely objections on the record. Remember, truth, proof, law, and relief. Make the necessary motions. Closing argument strategies, you want to summarize only the evidence admitted, tie facts directly to the legal instructions you expect the judge to deliver, anticipate the opponent's claim, and be ready for a rebuttal. After the verdict, if the verdict is against you, request a jury poll to ensure unanimity. And if legal error occurred and is preserved in the record, you may seek relief on appeal. But remember, an appeal is not a new trial, only a review of legal errors. Okay? So a trial follows a rigid sequence. Victory comes from knowing that sequence in advance and preparing your facts and objections accordingly, and keeping every move within the bounds of the rules of evidence and procedure. That is what you want to do. Okay? Got to make sure we do that. Jury selection. Okay, so what is the process of jury selection? Y'all still with me?
Yeah, I can hear you fine. Mm-hmm. We good.
With you.
All right, y'all still with me. Jury selection, though. The process of choosing a jury, okay, it's called voir dire, which is a French phrase meaning to speak the truth. This stage is the foundation of jury trial because it determines who will sit in judgment of the facts. Okay, so remember, the parties are given an opportunity to question potential jurors drawn from a larger panel. The purpose is not to find perfect jurors because no person is without personal belief or biases, but to ensure that the panel is seated as fair, impartial, and able to apply the laws instructed by the judge. At its core, the jury selection is about understanding the legal and factual issues in your case, the kind of juror more receptive to your position, whether any juror holds bias, prejudice, or preconceived notions against you or your cause, whether any juror shows signs of leaning favorably towards your arguments. Above all, it requires treating potential jurors with respect. A dismissive tone, a careless remark, or a disrespectful gesture can cause permanent damage in the minds of those who may decide your case. Okay? So what happens in the jury selection? The panel is called. The courts summon a larger group of prospective jurors than will be needed for the trial. Question process. The judge and attorney ask questions to determine jurors' impartiality, potential conflicts, or biases. Right? So questions may address background, employment, prior experiences with the legal system, and opinions that might affect judgment. Ain't that something? Now, you can challenge for cause. A party may ask the court to remove potential juror who demonstrates actual bias or legal disqualification. There is no limit to the number of challenges for causes, but they must be supported with specific reasons. Okay, each side has a limited number of opportunities to strike a juror without stating a reason, though these cannot be used for discriminatory purposes as prohibited. Then, after challenges, the remaining jurors are sworn in and impaneled to hear the case. So you got the U.S. Constitution, the federal rules of procedures, and these particular case laws as well. Batson versus Kentucky, Witherspoon versus Illinois, and Irvin versus Doe. Okay, so how to apply the jury selection strategy? You want to prepare questions in advance, craft lawful, respectful questions that reveal bias or potential prejudice without alienating jurors. Use challenges effectively. Request removal for cause when a jury admits bias. Use peremptory challenges strategically to remove unfavorable jurors, but be mindful of constitutional limits. No race or gender discrimination. Read the panel carefully. Pay attention to verbal answers, tone, and nonverbal cues. Compare what jurors say with your understanding of the issue in your case, and build rapport and respect, right? So treat every potential jury as a respected peer. Jurors often notice demeanor such as much as arguments. If they feel respected, they are more likely to give a fair consideration to your evidence. Secure an impartial jury. Your ultimate relief in the jury selection is to impanel a jury that is lawfully qualified, unbiased, and capable of rendering a verdict based solely on the admissible evidence and the judge's instructions. Y'all thought y'all just had to accept the jury, didn't you? You ain't know you could say something, huh? You ain't got to accept them, folks. And it says you can even get people in there based upon to your liking, right? That is the thing. So that's pretty dope, right? So make sure that the jury selection is not about outsmarting the panel. It is about protecting your right to an impartial jury and ensuring the fact finders begin the trial with fairness, not prejudice, right? Want to make sure. Opening statements. Each side is permitted to make an opening statement before evidence is presented in effort to prepare the trier of fact of the evidence that will be presented. The proper way to make an opening statement is seldom followed by lawyers, and unfortunately, judges allow wide variations from the proper way. So we'll examine the proper way first and then tell you what to do when your opponent varies from the proper way, which is all too likely, as you will no doubt eventually discover. So the proper way is, one, is you appreciate their time, patience, and attention. They are all going to hear testimony and see documents and other evidence. The judge will instruct them on how to apply the law to the evidence they will see, and you appreciate their time and patience and attention. That's it. The meat and potatoes of opening is what they are going to hear and see. You don't jump to conclusions. That's for them to do. Lead them to those conclusions. Tell them what they are going to see and hear. Things you believe will lead them to the conclusions you wish them to reach. Don't treat them as if they weren't smart enough to reach their own conclusions. You might tell them, you'll hear George Jennings explain what he saw and heard at the scene of the accident. You will see the shredded tire that doctor does right, and expert in tire technology will identify as the cause of the accident. You will examine the record of the defendant's multiple convictions for criminal fraud and forgery. The wrong way is you don't tell them Ned Nasty knew the tire he installed on my motorcycle was defective and would likely cause an accident. Ned Nasty cannot be trusted. Ned Nasty owes me for my injuries. No, lead the jury, okay, to reach the conclusion you desire. Do not insult the court by telling it what conclusions it should reach, okay? Do not. All right. Presentation of evidence. This is very important. Evidence is the heart of every trial. Once the jury or judge in a bench trial has been sworn in, each side has the opportunity to call and examine witnesses, cross-examine the other party witnesses, introduce documents, records, contracts, photograph, or physical exhibits, build a factual record that supports their claims or defenses. The essential truth is this: at trial, you are not required to prove every detail imaginable. You only need to prove the ultimate facts you alleged in your pleadings and, where applicable, to disprove the essential facts alleged by your opponent. So, what must be proven? From the outset of litigation, each party's pleadings allege certain facts. All right, from the plaintiff or prosecution must prove the elements of the cause of action or criminal charge. When it comes to the defendant, must prove affirmative defenses such as self-defense, estoppel, statute of limitations, etc. At trial, the evidence presented must directly support or refute those elements. If a party spends time chasing irrelevant details, they weaken their position and waste the jury's attention. Lawyers often attempt to distract their opponents with side issues, raising questions or disputes that do not change the outcome of the case. The disciplined party stays focused on what matters, the fact ties to the pleadings. Evidence that does not relate to the pleaded facts or the elements of the case is not essential to the outcome. Do not allow yourself to be diverted into proving irrelevant points. That's when you just literally say, objection, this is not admissible evidence, or objection, motion to strike evidence is not admissible, things of that nature, right? Now, what are the governing rules of evidence and procedure? The burden of proof in civil cases, the plaintiff must establish the claim by preponderance of evidence, the greater weight of admissible evidence. In criminal cases, the prosecution must prove each element beyond a reasonable doubt. So, order of presentation determined by official rules of judicial discretion. Typically, the plaintiff presents case in chief. The defendant presents evidence in defense. And then the plaintiff comes with a rebuttal after that, right? And then if you have any form of objections, that comes as well. Objection must be made timely and specific to preserve the issue for an appeal. If you do not object certain evidence that's not supposed to be there, then it's going to be used against you, okay? So organize your evidence, prepare exhibits and witness testimony in a logical order that directly proves each element of your pleadings. Use a trial notebook or binder that cross-references your pleadings with the evidence you will use to prove them, right? Focus on relevant facts, okay? Do not get carried away. Control the presentation. As always, demand the court follow the official rules on the order of presentation. If the judge or opposing counsel deviates improperly, make a timely objection and cite the rule on the record. This preserves the issue for the appellate review because that means they violate due process or they made errors in the court, which is going to lead in a reversal decision. Disprove opponent's allegation. While your priority is proving your own allegations, you should also present evidence that undermines the opposing party's claim or exposes contradictions, such as those depositions that you have, especially because once people lie and they get on the record and say something else, and then weeks go by before the trial, and they're going to get on that stand and forget what they said. So remember that. All right? Go look at Young Thug's case and watch what Lil Woody did. And all the stuff that he gave them in those interrogation room, and he got on that stand and just, I don't recall. I don't remember. I don't know. And that just messes up the evidence completely. Because the witness that they had is not saying what they were supposed to be saying. And he was given immunity. So it wasn't nothing they can do anyway. Anyway, trials are not about arguing theories or impressing the court with style. They are about proving the specific facts you pleaded and ensuring those facts outweigh your opponent's admissible evidence. Everything else is distraction. It's a distraction. Okay? It's a distraction. So don't forget that. All right, so remember the jury, standard jury instructions, many jurisdictions adopt official pattern instructions for common claims. You got special instructions. If no standard instructions exist for a particular issue, or if the standard instruction is incomplete, either party may request additional or modified instructions. The opposing party may object, and the court will decide which instructions to include. So pay attention to this. Pay attention to that. Let's go back. In a jury trial, jurors are the finders of the fact. They listen to testimony, examine exhibits, and determine what actually happened. But jurors are not permitted to decide what the law is. Instead, the judge explains the law to them through formal statements called jury instructions. Jury instructions serve one primary purpose: to guide jurors in applying the law to the facts they find from the evidence. Without proper instructions, even well-proven facts may not lead to lawful verdict. Therefore, before the jury is sworn in, both parties have the opportunity to request specific instructions and object to improper instructions and propose amendments or alternatives. So that means that when they're already going to have the instructions ready, and if the instructions don't correctly line up with the law the way that it is stated, remember, the law needs no interpretation. It means what it say. It is what it is. And we have to make sure that we fully know that, because these people try to interpret. We need no interpretation. So make sure that you have the jury is being given the right instructions based upon what the actual law is saying. Timing is everything. Requests for jury instructions are typically submitted in writing before trial or at the close of evidence. Okay, the final jury charge is delivered by the judge of the jurors because before they retire to deliberate. So if, example of civil instructions, if you find by the greater weight of the evidence that the defendant entered into a binding contract with the plaintiff, that the defendant failed to perform that contract, and that the plaintiff suffered damages as a direct result, then you must find in favor of the plaintiff. All right. Now, you can ask for that instructions to be changed if it's a little biased or wrong or whatever the case may be. If you find beyond a reasonable doubt that the defendant intentionally caused the death of the victim by the use of a firearm, then you must find the defendant guilty of the charge offense. If you find that a reasonable doubt exists, you must find the defendant not guilty. So remember, the U.S. Constitution is the Sixth Amendment. Then you got the Due Process Clause, the Fifth and the 14th Amendment. These are all jury authority for jury instructions, as well as the rules of procedures of the courts and case law. So Sullivan versus Louisiana, Spark versus the United States clarified the juries decide facts while judges declare the law. But again, guys, we have to make sure that they are actually given the law in the proper manner. If they're not, then it's our duty to make sure that we change it. But see, everything that I'm saying, guys, this is why it's going to be so important that when for the class next week, next Saturday, on the 13th for the Bill of Rights, for you to know your rights inside and out. And that also means your right of due process. Due process is a part of that right too, guys. That means understanding and knowing the procedures of the court. Also, just your rights in full. What to do, what not to do. Okay? So make sure that you prepare early, always. Want to fight for accuracy, make sure everything is on the record. Okay, everything. We want to protect the record. And always, when addressing the jury, juries are always observing you. Okay, so they assess your demeanor, respectfulness, tone, posture, and sincerity. Your credibility and conduct can either reinforce or undermine the evidence you present. Jury instructions are the lens through which jurors view your evidence. If the instructions are accurate, favorable to your position, you equip the jury to properly weigh in the facts in your favor. If they are misleading or left unchallenged, you risk losing even a strong case. Always prepare, propose, and protect your jury instructions. Okay? Always. Now, y'all still with me? Y'all good in here?
Yes.
Yeah, we on it. All right.
Yes,
Yeah, we good.
are.
All right, making sure we good now. Because this is important. See, a lot of people don't think about this type of stuff when going into courts, do y'all?
Not half of it. Not even half of it.
Not at all.
But it's important to know these things, right? Very important. Helps you be more comfortable, helps you know what's going on. You know, can't nobody talk over your head or slide something up under, they can't do that, right? So now we got the right to orderly proceedings. And the only way we're going to know that we have the right to the orderly proceedings and to protect that is to know the proceedings. So every party to a judicial proceeding is entitled to have their case heard in an orderly, fair, and uninterpreted manner. Court exists to adjudicate disputes according to law, not to host chaos. If the proceedings become disputed, whether by constant interruptions, improper arguments, or disorderly conduct, your ability to present and prove your case is undermined. It is the judge's duty to maintain order in the courtroom. However, the judge will not act unless a party timely raises the issue. You, as a litigant, must demand order on the record whenever improper interruptions occur. So, remember, a lot of these lawyers and prosecutors, especially when they see that you're not a lawyer or prosecutor, when they see that you're not one, they're going to try to interrupt you. They're going to try to make you look like you're stupid, like you don't understand the procedures and all of that stuff. So you must being able to protect your order and being able to say the things that you want to say. This also goes to a lot of y'all be on these Zoom calls and they will literally mute you. They'll cut you off. That is out of order. You have the right to present your case and evidence. And anytime that is taken away from you, you must preserve that record and you must protect that right. Even if you have to go up to a higher court, do a writ of mandamus or a writ of prohibition. You got to protect it immediately. You do not wait the next day or wait till the trial's over with. You do not sit up there because that's just like sitting up there letting somebody keep smacking you when you got a way to block it. So go to the higher court. and make sure that we do what's proper, okay? Make sure. So they got improper interruptions. Opposing counsel may cut in a critical point to derail your argument or distract you. Only lawful objections are permitted during your presentation. All other interruptions are improper. Direct argument towards you. Counsel may attempt to argue with you personally instead of addressing the judge or the witness. This is a violation of the courtroom protocol and is grounds for objection. Presenting evidence out of turn. Each party has a designated time to present evidence. Opponents may try to inject their own evidence or arguments during your presentation to shift the focus. This is improper and must be challenged immediately. Okay? Courts' inherent power. Courts have inherent authority to maintain order and decorum in proceedings. Illinois versus Allen. Judges are obligated to ensure a fair trial by controlling the conduct of the parties and attorney. Rule of evidence. Okay. The court shall exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth, avoid wasting time, and protect witnesses from harassment or undue embarrassment. Objections. Federal Rule Evidence 103. A party must make a timely objection on the record to preserve error for review. State rules mirrors this principle. If you do not object, the issue is usually deemed waived on the appeal. So how to demand and preserve the order? If your opponent interrupts without a lawful objection, stand and move the court for an order. Your Honor, I move the court to direct opposing counsel not to interrupt except for proper objection. You got to do it, guys. Challenge the improper argument. If opposing counsel addresses you directly instead of the court, move for correction. Your Honor, I respectfully move that the opposing counsel be directed to address remarks to the court or to the witness, not to me personally. Enforce proper order of presentation. If your opponent attempts to present evidence during your case in chief, object and require a ruling that they wait their turn, okay? Or your jurisdiction equivalent when it comes to federal rules, evidence 611A. Make sure that we preserve the record. Each time you object or move for an order, glance at the court reporter to ensure your objection is recorded. If there's not a court reporter in there, guys, make sure that you write the time, the date, and what was the objection about, and being able to write it in the affidavit later to file it on the record so that you can have that. Okay. Your Honor, I respectfully object to the denial of motion and request my objection to be noted for the record. Focus on your mission. Even while protecting the order, remain disciplined. Do not be lured into arguing irrelevant issues. Keep your focus on proving the facts you pleaded, disproving your opponent's allegation, demonstrating that the greater weight of admissible evidence supports your position. A trial can either remain a discipline process or devolve into disorder. The difference depends on whether you demand law and order on the record. Do not tolerate unlawful interruptions or improper tactics. By asserting your right to an orderly proceeding and focus solely on the facts and law, you safeguard your credibility and you preserve your record and maximize your chance of prevailing. Okay? So what we have here is a motion to demand order and proper courtroom decorum. So you can put this in as well. I'm not going to read all of this, but it's based on what we just said. Okay? So you can do that to the fullest. All right, hold on. I don't know what happened. Okay, that was it. Now, what is the jury versus bench trial? Well, when it comes to the decision maker, the jury does in the jury trial, the judge does in the bench trial. The role of a judge in a jury trial is to instruct the jury. In a bench trial, it rules on evidence, determines facts, applies laws, and issues judgment directly. The role of a jury in a jury trial is to find facts based on admissible evidence, apply laws instructed by the judge. The bench trial, there's no jury, and judge perform both fact-finding and legal ruling. So pretty much everything that the jury would pretty much do, the judge is pretty much doing it all in a bench trial. And that's just what it is, okay? So, and just know when it comes to jury, you deal with emotions because people are people. They are conflicted by what they're actually hearing, etc. So we just got to know the actual difference in that. Okay? So I think that is all for class today when it comes to our trial warfare and what happens in court. All right. So let's talk about it. Let's talk about it. Let's get some hands up and see what's on y'all mind. What's up, Chelsea?
Hey, what's up, Eric? So I have a question along the lines of preserving the record. Am I able to go in there during trial and record, whether it's on my Meta or via phone? And is there any type of law that supports that?
A lot of people sneak and record or just record anyway. But it is a public venue. You are able to record. They will trip sometime. But you can also, ask them for a court reporter. They'll usually tell you who to call or something like that as well. You can actually call them and have them present. They do charge, but for the most part, again, you could, a stenographer as well. Yes. So yeah, you can do that.
Okay,
If
thank
they
you.
let you do it, people do it all the time.
I mean, I have the Ray-Ban Meta, so I mean, it could be kind of discreet, but I didn't know if they would try to throw you out because of it.
Oh, you got the Ray-Ban Metas? Oh, man, I'm recording.
Yeah, the look left.
Man, click. What? I'm straight recording with them. I ain't got to ask me nothing.
I bet. Thank you, Eric.
All right. What's up, Ricardo?
Hey, what's up, bud? Blessings, peace. How you doing?
Pretty good, pretty good.
How do you object then if you are, say for example, like my court case is, well, one of them was straight paperwork. Like I didn't see a judge. So like, is that just responding then back and forth and there's really no objection there, or like how does that work?
It's just responding. If you're just doing it by paper, going back and forth to like a civil case, then it's based upon your answer and rebuttal. That is your form of objection.
Got it. Okay. And then when you said on the opening statement, right? Does that are you supposed to disclose everything there, or just a little bulk of what's going to happen?
I mean, you want to give the summary of what they're about to come into seeing. Like if I had to sit in front of a jury and I'm fixing to give them the summary, like, okay, here you are about to see that the particular lawyer, whoever, does not have delegation of authority to bring this cause of action because there is no form of lawful documentation giving the attorney the right to make this claim, or the bank, you're finna see the bank does not have, or at the particular time the bank made the claim, they never had the delegation of authority, stuff like that.
Right. Okay, I see it. Just give them the little sandwich worth, well, not the whole thing yet.
Pretty much, you just lead them to what they're about to see.
Gotcha. Okay, thanks a lot, man. I appreciate you.
All right, no problem. What's up, Jordan?
Hey, man.
What's going on?
How's it going, everybody?
Pretty good.
So I'm in Missouri. I have a trial setting date for September 8th. I filed a motion to modify custody because my baby mom is crazy. And they're going to set trial on the 8th. I've used my discovery tools. I have used the interrogatories. You got to the 8th to answer them, and a motion or a request for production of documents. You got to the 8th on that too. I just was wondering how much of this really applies to like a family law case. Oh, and I filed a notice of judicial admission because she had 30 days to answer it and she never did. So to lock in those answers, everything that was alleged in the initial motion, I guess, is considered admitted when not denied according to Rule 55.09, I guess, here in Missouri. And I was just kind of wondering, like, if you knew anything on how this applies to family court.
It applies the
compared
same
to civil court.
because it's still, you have, no matter what, family court, any court, you still got the right to face your accuser, and all evidence is going to be used against you or for you on your behalf, whatever the case may be. And you got the right to use those discovery tools to see so. You got the right to produce for the production of any evidence is going to be used. You got the right to question anybody, subpoena anybody, or any form of interrogatories or admission. That's a part of any case we go into.
Cool, dude. Right on. Hey, man, I appreciate everything you do, and you really, truly are a godsend. You really, truly are. I found you at a very, very tough time in my life, man, and you're amazing, man. You really are.
Man, I appreciate you, man. Appreciate you. Keep going. Stay diligent on what you're doing, man. Keep God first.
Yes, sir. Have a good one.
Absolutely. You too. Demetria, what's up?
Okay, Eric, I got so much going on in my case right now, and I'm just trying to figure out is the better course for me to I did request for a jury trial, a jury trial, a trial by jury. But what's happening in my case is that I'm still fighting my car people, and they put a fraudulent contract on the court, and the case is being monetized. 'Cause I got the QSIP number, and I got IRS involved as far as auditing the case. But what I think is happening with the opposing counsel is that they're ignoring what I'm putting on the record. They walked
See,
in court without.
be careful about the word ignore. When you say ignore, you're saying because like when you put something on the record, you're either entering evidence as a motion,
Mhm.
through motion to put something on the record, or you're moving the court to do something based off some facts or finding or affidavits and things like that that you're placing. So when you say ignore, that means that they haven't made a decision on your motions, meaning granting or denying. If they do that, that's violation of due process. Now, if they just simply deny it, that's not ignoring it. That's just denying it, and then they're moving forward. And then you can do a motion to reconsider along with a judicial notice on why they should reconsider in granting that motion. And you want to do that literally to make sure that you exhaust all remedies, because when it gets to the appellate court is going to see that you've done everything that you were supposed to do to fully protect your right. And now you have literally pointed that out. That is an error in the case, a violation of due process as well. And now they're able to preserve the record for you.
Okay. So what I did was I motioned to enter my evidence into the court, and I also motioned for the court to, for the plaintiff to give me discovery, because I'm challenging the contract and everything. So what took place is that nor the judge nor the attorney looked at anything that I placed on the record.
So they can't move. So what you need to make sure, so you mean it's saying they have it denied or granted, right?
They have not even done well. What I will say this: at least after court hearing, I did get my discovery. She's going to motion them to give me my discovery. So that's a win.
Okay, so
Because
you're
the other
getting your
court,
discovery then.
right. But they're like they're trying to be dismissive of the fact that if you alter the contract, that contract is not valid. They're trying to say they still have a lien, but they don't have a perfected lien.
But see, what
So
you
that's
gotta,
what
but see, you gotta look at what we just talked about.
Mhm.
So if they don't have any way of disputing of what you're saying, then you should be moving for a summary judgment, because what they're saying is
Summary
not
judgment.
worth anything.
Okay.
So, and then like don't get all bothered about what they ain't doing. Like they finna give you your discovery. That's fine. They're gonna do that. They can drag, they can take whatever, but they have to make sure that they follow the rules. And now if they was
Right.
just to skip over those motions and go right into to giving a judgment and all of that, now we got violation of due process of law. Right. And it's
Yeah.
your duty to make sure you protect that. So if they if they don't say anything at all about your motions, move forward, then now you have to literally let them put in a judicial notice of letting them know that they're violating due process of law, and that, you will exhaust any other remedies with a higher court to ensure that due process is followed and the proper order and procedures of the court. That's what you want to
Now,
make sure you do.
okay. Now she did try to do that, but I stopped her. I said until the plaintiff provides the discovery, we can't move forward with this case.
Exactly. That's what you're supposed to do.
I said, and I have a right to due process. I did let them know that.
And you do. And they was going to try you.
Oh, they did. Oh, they were trying. Because I challenged jurisdiction too. Because she was just like, "Are you saying my full name?" And I said, "I am the living woman representing the estate of, my entire name." So, okay, well, we'll see how it plays out. But about time like I said, I got a lot of things working in the back scene too. So, and that's that's also a conflict of interest if they're monetizing the case as well. So, but okay, thank you.
All righty. All right. What's up, Jamel?
What's going on, family?
What's going on?
Coolin', brother. So I just had a question. Remember, I told y'all I was helping out a lady. They evicted from her crib. She ended up losing the state. I helped her file in federal. So in federal court, I'm looking at the case now. She filed the motion. This is on August 12th, and it said it was a preliminary injunction for a request for order to show cause, and they gave the judge until yesterday, the 2nd, to response, but there was no response. So what would I just do a default judgment, or how that work?
It wasn't no response from what?
It says they had until 9/2 to have a response to the motion. Yeah, it said a response to the motion is due by 9/2 for the preliminary injunction. And declaratory, I had to file a verified complaint for declaratory judgment under 1983.
All
And they
right,
assigned
and
the
you made sure
judge.
they were properly served, everything like that, right?
Yeah, for sure.
All right, well, the only thing you can do now is move for a summary judgment.
Okay, bet.
And there ain't nobody disputing nothing.
Right, and then the dispute, yeah, I get it. Summary
So
judgment.
you need to
I
write out the
appreciate.
summary judgment for the judge so the judge can sign off on it.
I appreciate you, bro.
No problem.
Uh,
Absolutely. Y'all guys learned something today?
Yeah. Hey, can I ask you real quick off of what Jamel was just saying? Think we could just hit a summary judgment, even though we didn't get no response from the motions, right? That's what you told me, right?
But see, he's doing it because nothing he put in there was disputed. So it's
Oh,
more so about
okay.
what he put in as far as the complaint, the petition. Nothing was ever disputed.
Zero chance.
Got
So
it.
he
I
has the
see.
right to move on to a summary judgment immediately.
It took too long to eat them.
Okay. And how long they got before they could the motions get denied or not? They get 2 weeks. It's always like that. 2 weeks.
Well, read your procedures. It'll give the
Oh,
days.
for the state. Got you. Okay,
Yeah.
I got it. Okay.
Read 'em. It's different. Some, because each state is its own republic, has the right to its own rules, etc. So you have to read those procedures just to ensure. But all across the board, though, all states have to have the same thing. It just might be worded different under a different thing or whatever.
Got you. Okay. Yeah, I'm here. I'm in New York, so it's 2 weeks here. I just wondering if it was an all over the thing.
Oh, it
type
might
of
be.
situation.
For
Yeah,
the most
right?
part, it pretty much might be. I haven't really checked and see if it was all across the board like that, but for sure. But the main thing is just to know.
Got you. Okay. Yo,
Absolutely.
you are a big blessing, man. I do want to appreciate you, man, and give you your praises as well. You are like a light that I've never seen before, man. And you didn't change the perspective of how I see authority, cops, man, and how I see judges and inside of a court, how I feel inside of a court now is completely done changed. It's completely different. I feel the power within myself, and I want to praise you for that, because I didn't have that clarity before.
What's up,
And
Tony? Yeah, man. I mean, for me, it's like this. It's to the point to where, like I said, I've been doing this for a long time, and way over 10,000 hours in this. And my brother used to always say, like, man, why don't you go to school to be a lawyer? And I'm like, man, I ain't going to school to be no damn lawyer. I ain't going to do that. I ain't doing that. But then I thought about it. I was like, hold up. Why don't I just go and learn all the court procedures, both civil and criminal, inside and out, everything, just from myself. So I just started getting those books and reading them and going through them and understanding them. So just doing that. And what this is going to do for us is, because a lot of you guys, like, y'all know the law, y'all know consumer law, you know this, you know that, but as soon as somebody say something about court, boy, y'all tuck that tail quick. Man, I ain't going up in that courtroom. I don't want to file. I just want to do private administration. Listen, private administration, sometimes to some people, is just all bark. Man, you ain't going to take me to court. Take me to court then. You know what I'm saying? Until you can, because private administration is you trying to settle. And then usually when it's private administration coming from you as an individual, it's usually not going to get settled because they know it's not coming from a lawyer. So they don't think you got that type of power or access to know how to go through a court to do certain things. So that's how certain stuff, that's how it happens. They end up trying you. They get to wanting to try you as if you don't know nothing. Man, if they see a lawyer's not in this court, oh man, we finna run whatever kind of procedures we run in here. And if until you know, and they be like, and then you make a motion for the order of the court to continue with the procedures of the court in the proper manner, and then they gonna straighten all the way up now because now you just put some shit on record showing that they was acting out of order. You see what I'm saying? So it's like, oh, okay, we got one. He knows, he's aware. Then they'll start asking you, are you are you a lawyer or something? Start asking questions like that. But yeah, man, this is where we have to win at. And me personally, you guys are getting to learn a better way than I did. I had to learn by trial and error. I just jumped out there. Man, let me go try this court case. Let me see if I can sue him. I was on a suing rampage, boy. I lost a hell of a cases, but I learned though. I learned quick. But I was on a suing rampage. Anytime somebody did something, I'm suing. Let me see. I'm finna go in and try to sue him. I got about 30, 40 lawsuits on here for real. Like, no lie, for real. But that's what got me to the point to where I am today. That's what got me to be able to do the $25 money order and make sure I get the process to go all the way through and then take them to court and make them bow out at that time. Like, it takes you to be able to do that. And look, I did that. That started in 2022. It ended in 2023. And man, I'm 10 times better. Way, way better. So really the information that I'm going to be giving you guys in that paid in full class is going to be 10 times grand than what I did on that particular time. Because I'm saving you and I'm showing you other ropes to do things on being able to capitalize on the situation. Because one thing about people is what? People are lazy, they get complacent, they get comfortable. And when they do that, they start cutting corners, they start just doing stuff because they're used to doing it. And when it comes to these corporations, the only thing these corporations want is money. So trust me, it's going to happen. They'll slip up, they'll do it. You might have to try it once or twice and then 3 times, whatever. But hey, 3rd time's a charm. It happens. They cash that $25 money order, wait a certain amount of days, and just continue to pay like ain't nothing happened. Then after them 90 days, buddy, hey, you did not rebut me. I need all of that and some back. So you just got to play it smooth, man. I told you I do everything by strategy, being strategic and just moving in a proper way on how to do stuff. I tell you, you can step out here every single day, especially when you start knowing your rights, you start knowing the law, you start knowing how these people are supposed to be and how they're supposed to act. People make mistakes. Man is flawed. So every day man wakes up and steps to do something, he operates in a flawed way. Because that's why we say man has to go through what? Trial and error, because we know it's flawed from the beginning. We're looking for perfection in that, right? So if you wake up every day and we notice, man, listen, it's a lawsuit. Time you walk outside, you just don't even know it. Real talk. It's a lawsuit everywhere you go, and you are not even aware of it. All the time. Somebody always doing something, saying something, doing something crazy. They ain't got something done right, especially if you're working in fast food restaurants and all these other places. Even when it comes to building codes, half of them don't. They so want to get the building up so fast and in a hurry that they don't operate according to the building codes of the city, the state, and all of that. Now they got you living in an unsafe environment. Lawsuit. Y'all think I'm playing, man. I am serious. It could be brand spanking new, looking beautiful and everything, but it don't follow the codes. You knew it didn't follow the codes when you put me in here. It's unsafe, and we got a lawsuit. Just like that. So many of y'all apartments, it's out of code, molding places, all kind of different stuff, man. Stuff that y'all be letting these folks get away with. They'll tell you it's a gated community and the gate don't even close. You know what I'm saying? And you got a whole contract. That was part of the contract. So why is that not? That's a form of breach of contract. That's a lawsuit. We got lawsuits around us for days, though, but it just takes for us to be more inclined. Joshua 1:8. I always say that. Joshua 1:8. Read Joshua 1:8. Understand it, overstand it, and move in it. You have to, because that's what's going to take you to the next level when it comes to a lot of different things that be happening. Like, again, like we talked about earlier, like, man, most people get a bond, and the bond, you put up the money just for you to show up to court. And then we show up to court and we just walk off. We just let that money stay. Right? We was bonding out somebody at one point, and we had to give $1,000 to bond out this person, and still wondering what happened. But anyway, I kind of think I know. But the actual bail bondsman took the money and knew he couldn't get that person out. Lawsuit. But they think that because we look like this or look like myself or whatever, like they just can do shit to you like that. They can just step on you like that. And boy, till you start opening your mouth and they start realizing like, whoa, what is going on? Just like me being at Walmart one time, and I was driving all the way 10 miles out the way to go to this other Walmart because it was easy for me to send money, get money, receive money, and all of that type of stuff with, the ID and stuff. So, man, one day I was like, man, you know what? I am not going 10 miles out the way. I'm going to this Walmart. They taking my damn ID today. We're going to have some problems. I got time. I ain't got nothing else to do. So when I get in there and I show them the ID, they start looking, boy. When they ain't seen something, they get to looking, and they'll look at you in your face, and they'll look back down, they'll look back at you again, and then they'll look at I've never seen anything like this. Can you look at this for me? Yeah, sir. I don't think we're going to be able to take this. So which one of you guys are discriminating against my nationality and origin and my religion? Oh, I think we can find a way to make sure that we get this done for you. And then the thing about it was the manager, and the manager turned around and handed it to the other employee who had just started and said, hey, you deal with this. I know damn well you want her to deal with it and not you, because I said something about discrimination. I started talking in ways that's going to get your ass in trouble. So they hurry up, and guess what? They got the money. They took the ID. They did everything that they were supposed to do. Everything. Right? Just like I had this one dude tried to argue me about tax exemption. And if I got time, bro, I can walk everywhere in every store and be tax exempt. But it's just, what do I feel like arguing with this person today? And really, for real, if they tax me, I could honestly sue the shit out the company after I just exercise my right to be tax exempt. I could literally go on a rampage suit like that all day long, because you're going to have some dummy that's going to try to argue me. Number one, I need you to prove that I'm in resale, meaning that I'm finna buy something from you and go resell it to make a profit. You got to prove that first. In order to do that, you got to prove that I'm operating in a form of commerce. But I'm not doing either. Okay? I am the final consumer in the situation, right? So it's not a profit. It's not creating any form of wealth for me or anything like that, right? As well. And, well, if I'm buying it for any form of religious purposes, I'm tax exempt anyway, as well. You don't know what I bought it for. And I'm just telling you I'm tax exempt. Here you go. Oh, well, you got to have a tax ID from the state. No, I don't. It already says that we don't have to apply for anything when it comes to the federal or the state for any tax exemption. It's already been said, especially when it comes to 508. Matter of fact, man, here, use this number on the back of my passport card. Type that in. Tax exempt. Thought so. You have a nice day, sir. You know what I mean? And you almost just got yourself sued. You really want to get sued? You personally and the store like that you're working for, you want to go there to get sued. And that's exactly the type of stuff that can happen on a daily basis. All these big ass potholes in these streets and stuff like that. The city's supposed to be getting sued every day. City and county. State on the highways. If you up on the interstate highways, that's state. State got to make sure those right. If it's a big pothole or something happen, you hit it, sue the state. If you in the county area on the county roads and the county ain't taking care of, sue the county. If you in the city roads the same way, sue the city. I promise you it's there. We be laughing. We get on there and we laugh at these potholes that they be showing the videos of people running over them potholes and down there losing the whole axle. But the truth is they got a freaking lawsuit against the city. Right then and there. But people are not inclined into the law, so therefore we miss the opportunity to act upon our rights. We lose, and there we go. So we got to be better, guys. Just the reason why we're doing this. Like I said, yes, we can come in here and we can talk about money all day. I could take y'all through every negotiable instrument type of class that I could think of. But, man, listen. A lot of y'all get into so much shit with doing that, and then next thing you know, you calling me talking about something happened, and you can't even get yourself out of the situation because you doing extra stuff that you seen on YouTube or something. You know, like I've been wanting to teach the lawful money class so bad, but I know I need to teach this first. I know I need to make sure that you understand court, the procedures, and how to protect yourself and knowing the law and how to actually apply it. Because if I teach that first, you're going to jump out here head first and do some shit to get yourself in trouble, and you ain't going to be able to get out of it. It happens. You know how many people I done had that called me knowing they were supposed to be doing something, and right in the middle, the police is knocking at my door, and I'm like, what the fuck you want me to do about what can I do? That the police is, well, can you talk to them for a minute for me and say what? If I ain't the judge calling the sheriff, telling them to hold, and there's been another, the order is revoked or something of that nature, they ain't finna listen to what I got to say. They not. You know what I mean? So I run into that type of stuff all the time. And trust me, people will leave you with nothing, man. People come, they'll suck from all the energy from you that they can possibly take from you and leave you with nothing until something goes wrong for them and they come back looking for something from you. They will do it. I promise you. They will do it. That's understand that. So make sure that you guys out here, if y'all out here helping and teaching people anything else, man, protect yourself. You know, help people, but don't let people take advantage of you. All right. Make sure that for your work that you do, man, make sure they deliver. Make sure they pay. Real talk. Make sure they pay you. And why do I say that, y'all? And I'm serious when I say this, bro. I did a tax class for $100. People receive hundreds of thousands of dollars, et cetera. Not that I need y'all money, but bro, nobody gave $1 back to the cause. So that right there just tells me when there are people out here that you're doing what you're doing and you're teaching and all of that, and people just get mad because you're going to make sure that you're compensated for your time. That's your enemy. They don't want to see you with nothing. And you can help them get the whole entire world and do any and everything for them, but I promise you, people will leave you with nothing. So make sure you take care of you first. Y'all got that? Everybody.
I hear you.
And I'm not saying y'all will leave me, but I'm just saying it's been proven. I've seen it for as long as I've been doing it, helping people. Trust me. Right? And then some people feel like, oh, he got enough or you got enough. And they don't know what the hell you got or who got a hand in what you got. You know what I mean? But people look at you and think that anyway. So again, take care of you first. fill your cup up. Nobody should be pouring anything. You are a overflow. Okay? Because once you start pouring, that means you start taking from you. You don't need to take from you. Why do anybody have to take from you when the ultimate source is God? That's where I'm going, and that's exactly where I'm gonna tell your ass to go. Shoot, my cup is being filled up by God, and in order for that to continue to go, then I got to make sure that it's an overflow, and that's what God does in your life. So you shouldn't have to ever pour, ever. Be an overflow. I appreciate you guys for the night. It's been a great class. If you had to rate today's class, what would you rate it?
Unlimited, top of notch.
Infinity.
So with that being said, guys, I appreciate you as always. Get in these classes, more so the Bill of Rights class. I really want to see more people in the Bill of Rights class than I do see in this paid in full class about a car. I know that class is going to be packed out. I already know it is. But this Bill of Rights class need to be just as packed, especially at $50. And what I'm going to incline to give you to make sure that's going to be able to be passed down from generations into your family to make sure that they know their rights and how to stand on those rights as well. All right. Don't forget that our trust setup is still $600. It's half off right now, guys. So you're still able to go get on there and do that as well. This weekend, for those who had the Hidden Ledger class, we're going to be doing the Q&A. You guys had plenty of time to study, to go over the different classes that was given to you as well in that. So you should have enough questions to gain enough understanding, right? Hope y'all ready. As always, again, appreciate you, love you, keep God first, and y'all have a great night. We out of here.
Thank you, man.
Thank you.
Blessings, man.
Thank you.
Gratitude indeed, bro.